Yes.
Item number 26, I beg to mention it.
Item number
26, Your Lordship. For my senior, he, well, Your Honor.
20.
26, Your Lordship.
What happened to your senior?
He's not well, so
What happened to him?
he's not well.
Not well. He was arguing yesterday. So that's why we are worried. What happened to him? Item 26.
Yes, Your Lordship.
Who is your senior?
Sir, A.M. Bora.
He was arguing yesterday. Yes, what happened, Mr. B. Chaudhary?
Properly, because
Okay. Okay.
he has come to the court, but he is not fully not prepared yet, sir.
Okay. When?
1 week.
Give a date as per your convenience.
May please, Your Lordship. Lordship, with regard to item number 11, can it be after 2 weeks, Your Lordship? I'm making a mention on behalf of Senior Counsel Mr. A.K. Bhattacharya, Your Lordship. It was some medical emergency yesterday evening. He will not be able to argue, Your Lordship.
What is the issue here?
I'm extremely sorry, I'm not aware of the matter because I'm appearing on his.
Okay, when?
After 2 weeks, Your Lordship.
After 2 weeks.
Much obliged, Your Lordship.
Yes, Mr. Mune.
Number 18 and 19, Madam. We have engaged Mr. A.M. Bora. I've taken the consent from the other side, Madam. 18 and 19.
After 2 weeks.
Mine.
I am praying for listing of a criminal petition matter 2000 orders.
Next week.
Lordship,
Make a mention next week. Let us streamline the things. At least we have reached in 15, 16. Let us see for 1 or 2 weeks. We'll allow. Everything will be listed.
Lordship, item number 18 and 19, Lordship, there is an interim, Lordship, that may be continued.
Interim order passed earlier. Shall continue
Deeply obliged.
till the next date of listing. Yes, Mr. Kamar.
Madam, as regards our item, my lord, as regards item number 8, I have been just recently engaged, my lord.
Very good ground. One is Mr. A.M. Bora not keeping well.
My lord, no,
And it's very good that senior
No, but-
engagement is not necessary.
all these are-
And other is that I have recently been engaged.
No, my lord, one thing only, my lord, I don't need adjournment, I need certain accommodation only for a day or some.
Okay. Which
That
item?
regarding is
Item number?
8. I'm glad, I'll be happy and glad to.
It's
Before your lordship, but
give thanks to the dusty files.
Dusty.
Dusty files for
Achha.
2005 to then. That has created some problem.
Dust.
That's why I am a liberal in granting adjournment today. He
Your lordship
myself is not
taking
keeping
19
well
all galaxy
well
power.
for these dusty files. And
Yes,
thanks
madam.
to
They are
all,
also touching.
thanks to lawyers like you. The efficiency in keeping not arguing these matters for last 10, 11 years.
That's true, madam.
But we are breaking your efficiencies.
Yeah.
That is for sure.
No, that's fine, my lord. Ultimately, one has to call it a final day, my lord. Every day the curtain
But
will.
final day is
No,
now
that has
for
come,
last, this is a matter,
Cinema,
10 years,
cinema.
final day has not come. And that to criminal petition.
Right, right.
Ought to have been at the
At that threshold,
immediately.
madam.
8 and
8 and 10, my lord.
8 and 10. Give a
Sure.
date. December. Let us see. Yes.
That will do.
Don't say
No,
that.
no,
on
no
the-
more, no more, no more. In the meantime, we'll gear up, my lord.
You have all the instruction, everything.
Well,
in-
yeah,
Yes.
item number 10 only, interim to continue.
Interim to continue item number.
That's all. We'll do it, my lord. Sincerely, much appreciated.
Is that is there? Where is the affair?
FIR is, my lord, page 11, my lord.
Yes.
11, type 2.
Page 11.
Earlier rejected, look.
I have seen this.
I'm not the FIR net.
Oh, that case. Creating loans in the
Loan.
name of some person. Who is he?
Lordship, he is the
Huh?
Tahir Lordship. He helped in the transportation Lordship.
Transportation of the vehicle to
Yes,
Bangladesh.
Lord. No,
No,
Lordship.
this is not Bangladesh.
No, Lordship to Arunachal, Meghalaya.
So they create a loan. Loan is
Lordship.
sanctioned with the
Lordship.
bank.
Lordship.
Bank's officials are also involved.
Lordship.
Huh? Then loan is sanctioned, bike is delivered, bike is
Okay.
transported, and thereafter there is nobody to
No.
repay the loan.
Lordship.
I've gone through the case there.
No new grounds also, dear Lordship.
Huh? You are not FIR them case. How can I tell without looking at the city everything? I still remember your modus operandi.
Yes.
Some people are said you will be given a job.
Lordship.
So therefore, we need your Aadhaar and all because we
Bank-
cannot pay you salary through cash. We'll have to transfer your amount to your bank account. Is not it?
Lordship.
Then these people, very poor people, their all documents are whatever required for opening a bank account is given. Then bank account is opened. Thereafter loan is sanctioned. Bike is delivered and bike goes to what not Arunachal up to Bangladesh. And in the meantime, there is nobody to repay the loan.
Sure.
And these people cannot repay the loan. And he is the person who transported. Dismissed. Yes, Mr. Vorali, what was this?
Sir was earlier taken up several times for hearing, but only appeared for respondent number 2.
Ah.
Thereafter, there was an earlier order
Ah.
whereby registry was directed.
What is the issue?
This is the matter against my lord.
Medical
division,
negligence.
Against
Medical
framing of charge.
Framing of charge.
Framing of charge.
Now, framing of charge on the basis of an investigation.
No,
By
the
a-
basis of an investigation, thereafter police file final
Charge sheet?
report, but
Final report.
final report, but court took cognizance.
Ah.
Under 304,
Ah.
omitted the matter for to
Trial.
session court
Ah.
for trial.
Ah.
Trial court found that there is material to frame charge under 304A.
Okay.
Hmm.
Again, matter was remanded back to the CGM, challenging
He
that.
was a
order.
doctor or what?
Doctor, negligence, medical. Matter may be taken up for hearing immediately, my lord.
We'll take it up today itself. Why the informant is required in this case? 304A. Earlier it was there, High Court rule says not necessary. Isn't it? It is not an offense against women or something like this. So the person had a chance to participate in the
Right.
proceeding. He has not, so we'll proceed with this matter.
From whatever material is there, my lord, even if are taken,
What kind of negligence piece? What is the materials collected by IO as regards negligence? What was the fact?
absolutely no
Nothing.
material.
What was the alleged offense?
Allegation is, my lord,
Hmm.
this informant's daughter,
Hmm.
she was admitted for delivery of child.
Hmm.
And while after delivering the child,
Hmm.
there was blood loss.
Hmm.
And that particular hospital, they didn't have blood bank.
Hmm.
It was also not mandatory to have blood bank. And my lord, immediately blood could not be arranged at that point of time.
Hmm.
And that was late at night. So after the father of the the informant,
Hmm.
he lodged an affair that too after a gap of about 10 days, that as daughter expired due to negligence of the doctor, so the doctor may be.
You have the copies of the 161 statement and
all
all are there. Heard Mr. S. Borelli, learned counsel for the petitioner. The present revision petition has been preferred. Assailing an order dated 22/9/2011 passed by the learned additional session Judge Kamrup Guwahati in session case number 185 within bracket K/2009, whereby charges under section 304A IPC has been framed against the accused petitioner. Full stop. Though notices were issued but the respondents notices were issued and respondent number 2 was earlier represented by Dr. G. Lal, who in the meantime expired. None represents for the petitioner. Respondent number 2. Full stop. In view of the nature of allegation, the presence of the respondent number 2, impleadment of respondent number 2 is not necessarily mandated. However, said respondent number 2 shall have all right to participate in the proceeding. In view of the aforesaid, let this matter be taken up for final disposal when? Next week,
Thursday, my
Thursday. In the top of the list,
problem.
fifth top of the list. Keep this, huh?
Okay, no?
Service of notice
My
to
lord,
confer.
that report not received, my lord. Today in 5 and 6 both, my lord.
Huh?
Put the item, we have not collect the services.
Next 2 days. No. Today is Wednesday, Friday.
Right.
You'll have to have it.
My lord.
Mr. Sharma, learned additional public prosecutor on behalf of Mr. Borthakur, learned additional P. Borthakur, learned additional public prosecutor, submits that he may be granted 2 days further time to complete his instruction in terms of this court's earlier order dated 19/11/2024. Prayer stands allowed. List this matter again on 29. Yes, Mr. Sakya.
5, 6 same, my lord.
Huh?
5, 6 same, my lord.
Same. Okay.
Same order, my lord.
Okay.
Mhm.
By 29. Yes.
For the matter for the timing.
Why? Why this
Yes, sir.
matter is listed today? Oh, Nawaz. Who is Nawaz's case? Okay. We'll,
Yesterday,
yesterday. Okay. We'll take up later on. Yes, Mr. Goswami.
Yes, this is also fine. He has told my lord, dispute has already been being resolved, my lord. And the situation I have explained in the affidavit of the deputy commissioner.
You don't want to press.
Otherwise, lordship, pause of action.
Tell us, the circle officer, you are happy with the circle officer, why should we unnecessarily go in?
Yes, and he has also, petitioner also has not, my lord,
Learned
applied
counsel
this
for the
honorable court.
petitioner submits that he has instruction not to press this petition. In view of the aforesaid, the present petition stands close on withdrawal. Dismiss on withdrawal. Mr. B.D. Goswami, B. Goswami, learned additional advocate general, submits that he has no objection if the matter is withdrawn. Then accordingly this.
Lordship, this is state again,
Mm,
we are not prepared to do lordship on 29 lordship.
leave petition, leave, else. Leave was granted. Okay, isn't it? Hard. Mr. Swenso.
Take it down.
No, he is the appellant. He is the state is the appellant, is that it? Additional public prosecutor. This is an appeal against Swenso.
Next week,
This
Lordship.
court, under its order dated 11/11/2024, has already granted leave to appeal to the state. First up, peruse the impugned judgment and the materials available on record, admit, call for the LCR. What is the offense? LCR is already, LCR has already been received. Issue notice to the respondent number. Respondent numbers, how? To the respondents. To the
Respondent represented lordship.
1 to 10.
Or two is there, two is represented lordship.
Who is?
As per cause list.
Okay, to issue notice to respondent number 1, 3, 2 and 4 appeared.
Two is there lordship.
1, 3, 4, 5, 6, 7, 8, 9, and 10. Steps be taken.
On next week.
Steps for issuance of notice be taken by both ways, so within 5 days. List after 4 weeks. In the order column. It will take some time. Yes.
Respondent number 2 is
What is the matter?
for quashing of GR case number under section 384, my lord. 384, extortion.
Where is
It's pending in the Court of the Learned Judicial Magistrate, first class Kamrup, my lord.
okay, where is the FIR?
It's at page 16, my lord. That is the type copy. Page 16 is the type copy and 17 is there. So lordship may kindly come to page 4, my lord.
Page?
Page 4, paragraph 7, my lord. Both the parties, they belong to the same locality, my lord, and they are friends also, my lord. Whatever. Page 4, my lord.
No, what is your ground? Can there be a ground to quash until unless both of you come forward and say that there is a misunderstanding dispute, we should exercise
Lordship may kindly come to page 4, paragraph 7, my lord.
Page 4.
Paragraph 7.
7. Okay, then.
Both the parties are friends, my lord. So what the respondent number 2 has
Paragraph
thought-
number 7.
Yes, my lord.
That it may be of relevance. Starts with.
Yes, my lord. Because this is relevant because both the parties, they are of the same locality, they are friends, my lord. And one day, on the day when the incident took place. my
Where
lord,
is that their friends and information petitioner are friends? Search sheet file. This is in paragraph 7.
Paragraph 7, like it's regarding involvement of.
Involvement of that person in another
and
case.
your lordship may kindly peruse paragraph 6 again.
Paragraph 6.
Yes, ma'am. Page 3. So he thought that I was the one who has instigated the police to search his house for him to be arrested. So all the blame has been put on me, and due to that, he has instigated this case again. I was trapped, my lord.
Now, okay, this is your ground. Now then,
So that is my ground. And ingredient of
now please tell us, madam,
384
for
is not there, my lord.
that will come later. Your first ground, let us understand. You say that he has a malicious intention.
Yes.
He suspected you
I was the one.
that you are involved in his arrest.
Yes, ma'am.
This is your case. So to quash that, we'll have to come to a conclusion that this fact is material, this fact is available on the record and undisputed. Until and unless that is there, Can we quash this proceeding on this ground?
If your lordship will
No, no,
see,
please answer this question. Yes or no? No. No. So that ground is gone. Now come to the next ground.
lordship may kindly see the FIR, my lord. In
Okay.
the FIR, ingredient of section 384 is not there at all, my lord.
What 384 says?
384, my lord.
IPC.
Punishment for extortion
What extortion is defined in IPC?
in 383, my lord.
What it says?
Whoever may I read, my lord?
Mm.
Whoever intentionally puts any person in fear of any injury to that person or to any other, and thereby dishonestly induces the person so put in fear to deliver to any person any property or valuable security or anything, sign or seal, which may be converted into a valuable security, commits extortion, my lord. I was
Now, what are alleged in the FIR? Please let us.
FIR.
What is
only-
the FIR is that you were
It
put in
reflects,
put-
it reflects only the trapping part, my lord. I was invited to his place, my lord. Thereafter,
no, these are facts. These are facts. Whether
thereafter he put the envelope inside my pocket, my lord. Then 2 or 3 people came out. Then one of them identified himself as the executive magistrate, the others as CID officers, my lord. Thereafter, a search was conducted, and this is the envelope from my pocket, which was put by the respondent number 2, my lord. So from that envelope, 10 notes of 100 rupee notes of amounting to rupees 1000 was found, my lord. It was a trip, my lord. I was just invited to his place. We are from the same locality. I am a businessman. He is an advocate practicing in the party, my lord. There is nothing other than that. Just to trap me because he thought that I was the person who has told the police regarding his involvement in that Arunachal Pradesh case, my lord, for which he was arrested also. Other than this, nothing is there, my lord. How can this constitute evidence of section 384, my lord? That's due to his malicious intention, because he
It is
thought
the
that I was the
difficulty.
person who
You'll have,
instigated
there
the
must be material to
but
have a
just-
satisfaction to
but
power, exercise power under 482, that these are malicious. Mayor accept statement, nothing is there. Specific allegation is that he had demanded money, put into me pressure, so I have informed the so and so has laid a trap, and it was recovered. Now, these facts prima facie are available on the record that there was a trap, these are the notes, it was seized. Whether it was malicious or not, can we now give you a clean sheet in a 482 petition? That's all.
Lordship will kindly see the FIR. From the FIR, it's not clear whether I have taken the envelope from him. He was the one who has put it inside my pocket. And being friends, your lordship knows only sometimes it happened. And same locality. I am now an old man of 64 years, a small businessman. He is an advocate. He knows what to do, my lord. I am a layman, my lord. From the whole thing, it's very fishy only, my lord. And he himself was involved in a case involving around 20 lakhs extortion, cheating, forgery.
That we understand.
So
That
due
we
to that-
understand.
and
How are you linking these two things? Any material except your statement to
Yes,
say that something was, who is the lawyer? Lawyer someone, no, no,
this
no.
one. Anjan Kumar Das, my lord.
Specific allegation is that you are threatening to and demanding money of 50,000. There is
That's
there is
what he
allegation of demand that you have illegally demanding 50,000 and want to extort
That's
it.
what he said, my lord.
That is Miss, Madam Court, please tell us our power under 482 to decide on facts. That this fact, Madam Court's client is correct, he is not correct. These are false facts. We can even go into that in exercise of 482.
Lordship,
If
may-
we are having some material, suppose there is some allegation, a suit is filed, in a plaint, he has written a different story. Plaint is not denied. It is a legal document. Then he says something. Then we can gather something that there is a malice on his part. Here is specifically said so and so demanded me 50,000 and threatening me to lodge criminal cases. So accordingly, I have informed so and so. A trap was laid. Money was recovered. Fine. This is
Immediately
this
after
was
my
this was
arrest.
see, listen. This is now the case diary. It is there that these monies were recovered in presence of independent witnesses. So these facts are before us. On these facts, how can we exercise our power under 482?
A small prayer.
Yes,
Lordship may give me some time. I'll
that
look
may be
into
a
it, huh?
good
I'll look
prayer,
into
but
it.
until and unless you can convince me
Yes, ma'am.
that this is a fit case where we will not hesitate to quash an application. That is for sure. But I do not think this is a fit case for. There may be whatever you have said may be correct, but we cannot presume things in a 482 case. The prayer of MS KM Core, matters and St. John be listed. When?
Next year if possible. Next year.
Our idea is to start next year with 16 or 17, not this 11, at least no more 10 years old cases. So we'll give it, we do not know will be possible or not. In the meantime, the dust has already affected. If in this month, let us see.
When, my lord?
Otherwise, it will take until and unless you say something, it will take 3 paragraphs to dictate this order. 29th. Okay, let us see.
Let the interim order continue.
Interim order passed shall continue till then. Of course, if two neighbors comes with a joint application saying that this is what happened during pendency, we will exercise power under 482 if permissible under law.
Right, also.
Yes, Mr. Tiwari.
Lord, on the last occasion,
Hmm.
Lordship wanted to know the status of arbitration case.
Ah.
Hearing has been concluded,
Hmm.
judgment is reserved. As far as my lord, the FIR.
What is the issue here? Where is that?
Quashing of FIR, page 134, your lordship.
Page
134.
134. Yes, so that case.
Lordship, we have been informed that the case has been charge sheeted, Lordship, last year, July, Lordship.
Ah.
We are trying to, Lordship, retrieve the contents of the charge sheet for your Lordship's perusal. And maybe
My
give it
lord,
out.
there is a decision, my lord, then after filing of charge sheet, your lordship.
Yes.
No, no,
That
there is
on-
no problem on
under
this.
dispute.
Recent decision, there is no problem on this.
Of challenges, my lord, FIR does not disclose any cognizable offense on the face of it. Number one, your lordship. But to my lord, the nature of case is purely civil in nature. And my lord, for that arbitration proceeding initiated and my lord, hearing has already been concluded. There is decision that when there is an
Yes, Mr. Bothakur, according to you, which are the statements which can be said to be a commission of offense? Which are the statements?
In the FIR, Lordship, we have alleged that in collusion with one of our own employees, they have created false bills in
Where
their
is that?
favor.
Where is the statement?
That is in
I will show my minutes of meeting also. That limited 10, more than 10 crore.
When the judgment will be delivered?
And so far, my lord, regarding FIR which we lodged in Mumbai,
Ah.
they preferred repetition before this honorable court, and this honorable court has dismissed that.
That is for non-prosecution, Lordship.
Whatever-
I have been
but-
informed that the client plans to restore.
The other affairs and all are in part of this.
My lord,
Huh?
everything. If your lordship will hear me, I will place it.
Okay. Just let us understand what are your criminality attributed.
And 130.
Prepared or not prepared, Thakur?
Lordship, I have the FIR, but in petition, I am not, Lordship.
Give a
I-
copy to him.
130.
130. I found it, Lordship.
Okay.
Here.
Which are the paragraphs tell us?
If Lordship looks at paragraph 11, Roman 11, Lordship. Here, where we have made the main contentions at sub-para A.
Hmm.
Informant number 1 was shown a statement dated 3rd August 2011 given by Mr. Molloy Dev, who is our employee. In the said statement, Mr. Molloy had stated that on an average, every month pharmaceutical formulations manufactured by Unichem, which is the petitioner here also, amounting to almost 30 lakhs were sold by Candid, which is us, Lordship, to unknown parties in Guwahati, which were filtered into markets of Bangladesh and Bihar. It is admitted by Molloy Dev that he made fictitious invoices of stockists and duplicate lorry receipts of Vishal carriers and was helping stocks to move into these markets. He has also admitted that he was carrying out these transactions of issuing fictitious invoices and making supplies against the duplicate lorry receipt copies of Vishal carriers at the request of accused number 5 to 9, Lords, who are the petitioners. He has stated that he was forced and pressurized by accused number 5 and 9 to do these transactions, and the said statement is signed by Molloy Dev in presence of accused number 3 and 4. B, Lordship, the said personnel from Unichem pointed that there are a lot of discrepancies in the invoicing done by Candid, and materials were dispatched through fictitious lorry receipts of Vishal carriers. In their FIR, Lordship, they have contended that we have not made delivered the goods, and we are raising false invoices, and we have alleged that false bill in their favor has been raised by one of our own employees in collusion with them, Lordship.
Contrary to the minutes which they have signed.
Where is this minutes? 4th August 11.
Page 61, my lord.
Yes, 61.
61.
Huh?
Page 61, 61, Annex 3.
What are the offenses registered?
Under 420, Lordship, it has
420,
been
468, 471.
charged, Lordship.
120B, 420, 468.
120B,
420,
420,
468,
468,
71.
4.
71. 71.
Okay. Page? Page?
Page 61 is the minutes. This FIR was after lodging of Mumbai FIR.
Page 61.
61, Annex 3. Minutes of the meeting held August so and so. For my lord Candid Drugs, my lord complainant present, my lord Gautam Banerjee, he also signed. Unichem, close one, observed lot of discrepancies in invoicing done by Ms. So and so, various stockists on behalf of Unichem, and Unichem handed over all the details of invoicing done by Candid for the period so and so, amounting to 77. was noticed that all these invoices raised by candidate on different stockist names. The material has been
Case
discussed.
that is here.
Inside
LCR is here. Give something.
My lord, after observing close to my lord, page 62, my lord, narration that what they have done. Total overdue outstanding of Messrs.
Where? Paragraph 2.
Distributed due to bill came as on 31st March 7 is 12 crore 15 lakhs something. And all invoices, wise details of outstanding or Unicom statement of.
The
either
present
account-
application is filed for enforcement of FIR dated 6/3/2013, registered as Panbazar PS case number 64/2013, laws under section 120B, 420, 468, 471 of the IPC. It is submitted by Mr. Bothakur, learned counsel for the informant that already search sheet has been filed. Being search sheet number
122 of 23, Lordship.
122 of 2023 before the learned
That
Chief Judicial Magistrate, of course, isn't it?
CGM.
CGM Kamrup Metro.
Metro.
Kamrup Metro. Registry to call for the case diary. Scan copies of the case diary and the record pertaining to the said search sheet corresponding to GR case number
64 of 2013, Lordship.
65 of 2000.
64, Lordship.
64 of 2013. List this matter on January give a date. Mr. Bothakur, this search sheet is file will just see all the facts admitted, things, lodging of your FIR, his FIR. Prima facie, we think that this is not a case to be criminally prosecuted, subject to what materials are there. That's why since search sheet is filed, we'll just pay.
By that time, my lord, arbitration award also.
January. 7/1 to be paid.
Deeply.
Come prepared.
Obliged.
Yes, Mr. Bora, somebody took some adjournment on your behalf.
One item, my lord, only hearing item, my lord.
Yes,
The rest of the item, my lord, I'll do.
you are fit and fine. For rest of the items, you are fit and fine.
Only one item I have prepared, my lord, the first one.
Okay.
The rest I have not prepared.
Okay, no issue. আটটা সামনে কোনটো আছিলে না অংশটো কোনটো আছিলে egg well. Yes, item number
12.
Your Lordship.
yes.
I request your Lordship.
Then we'll issue a notice after listing the methods in the Telegraph channel and website that lawyers are requested to reconstruct their files if not there since 2009 to 2019. It is submitted by the learned counsel for the petitioner. How will you reconstruct it? That they have misplaced their file and need some time to reconstruct the same. Accordingly, press for an adjournment. Rest allowed, this matter on. No, December, all this 2015 may fix into. We'll see, 18th of December.
With the lordship. Or after 2.
Why?
The council couldn't prepare.
We are not so kind that we will fix it only on making a submission. We must know reasons why we should.
Lordship, senior council couldn't.
What is the case about? What is the case?
I sold one land lordship.
Huh?
Out of 18
Where
lakhs.
is the affair? Where is the complaint petition which we want to set aside? Huh? All are same in the same boat, brothers. We are dismissing this until and unless you can say that this is the complaint petition. Your name? Heard Mr. S. Bora, learned counsel for the petitioner. Also heard Sir K. Das, learned counsel for the learned additional public prosecutor. Do respondent do name of the learned counsel for the respondent number 2 is shown. None appears for them. The present application under Section 482 of the Code of Criminal Procedure 1973, read with Section 401 of the 401 is filed seeking quashment of Photosil Ambari PS case number 89/2015, registered under Section 406, 420, 506 of the Indian Penal Code. Initially, the petitioner, Sri Nagendranath initially, the respondent number 2, Akhil Chandra Talukdar, filed an application under section 156 within bracket 3 of the Code of Criminal Procedure with a prayer for a direction to the officer in charge, Potasil Ambari Police Station, to register a case in appropriate section of law. Such complaint case was registered as 275 within bracket C, 275C/2015. A reading of the aforesaid complaint discloses that the wife of the complainant, namely Bijuli Kolita, had entered into an agreement of purchase of a plot of land measuring 1 katha 10 lesas covered by dag number 419 within bracket old 3641 within bracket new under patta number 482 situated at village Fotasil EB under Beltola Moja with the present petitioner and the wife of the complainant paid accordingly and registered agreement being registered deed number 10980/2014 dated 14/10/2010 was entered and the wife of the complainant and the complainant paid and total amount of rupees 9,30,000 as an advance. It is alleged in the complaint that on 5/1 entered and accordingly possession was handed over to the wife of the complainant. Wife of the complainant. However, on 5/1/2015, the complainant went to the house of the accused person to discuss about the matter. The accused person expressed his ill motive that he will sell the plot of land to another third party. 30, and if complainant makes any obstacle, the accused person will kill the complainant. Thereafter, on 8, as per the complaint, as per the statement made in the complaint, thereafter, on 8/1/2015, the accused person sent a legal notice to his advocate alleging that seeking permission for sale was the respondent of the complainant, but complainant which has not been done. However, done, it is the contention of the contention raised in the complaint that in the agreement, it was agreed that accused person is to apply for necessary permission. In view of the aforesaid fact, it is apprehended that the accused person is dishonestly willing to dispose of the said plot of land to any third party and also fraudulently deceived the complainant for his right. It was also alleged that the accused intend to grab whole money from the complainant and the intent to sell the said plot of to any other parties. On the basis of such complaint, the learned Chief Judicial Magistrate Kamrup Metro, under its order dated 11/2/2015, passed the impugn order forwarding the aforesaid complaint to Fotasil Ambari Police Station for registration of a case under appropriate section of law and also submit FF in due course after proper investigation. Full stop. The learned counsel, referring to the materials available on record, including the suit for specific performance filed by the complainant before a competent forum, has urged that the dispute is civil in nature and unnecessary, a criminal color has been given to it. It is the further case of the petitioner that there is no material on record to forward the aforesaid complaint to the for registration of a case, inasmuch as there is no statement whatsoever that the police has refused to register a case and that a cognizable offense is, even after a cognizable offense was disclosed. Yes, par contra, learned counsel for the respondent number 2. Yes, what is your argument? What is your argument?
I was from that land, my lord, and I have paid 5 lakhs, my lord.
So these are the facts. What is your case? You have lost the FIR. What is your case? Tell us.
It's been too long, my lord.
Huh?
To you, my lord.
The learned counsel for the respondent number 2 submits that he has nothing to submit and he will abide by whatever this court decides. Full stop. In view of the aforesaid arguments advanced by the learned counsel for the respondent number 2, this court has perused the material available on record, which are not disputed by the respondent number 2. From the record, it is seen that a registered deed of agreement for sale was executed between the petitioner and the informant for sale of a plot of land measuring 1 katha 10 lesas covered by agar jekhane chilo swencho. It is also on record that the petitioner accused has issued a legal notice through his lawyer alleging that the complainant respondent number 2 has violated the terms and condition of the agreement for sale by not applying permission in spite of several requests made by the petitioner. And accordingly, it was intimated through the said lawyer pleader's notice that in the aforesaid background, it was requested through the pleader's notice to the complainant to take back the advance already paid amount to rupees 8,50,000 within a period of 7 days. In the aforesaid backdrop, admittedly, a civil suit was filed by the respondent number 2, which was registered as title suit number 26 of 2015 for specific performance of the contract and injunction, and the subject and the subject contract is an agreement for sale as recorded herein above. In the suit, it was spread in the suit a decree in the aforesaid suit, a decree of specific performance of contract was sought, directing the defendant therein slash accused petitioner to accept the remaining amount of money and to execute a sale deed. Full stop. What happened to this suit?
That appeal is pending before the High Court.
Suit was decreed in favor of
Decreed my lord ex parte, so that is why against that.
against you.
And that's the appeal was paper.
It is submitted at this stage. It is submitted by the learned counsel for the petitioner that the suit was decreed ex parte in favor of the accused and against the present petitioner, which is now pending for consideration in an appeal. Full stop. In the aforesaid backdrop, this court finds what is foreseen, and accordingly the present criminal petition stands allowed by setting aside and quashing so on and so on.
Right.
Yes, Mr. Bora.
This is quashing of complaint, my lord.
Who is for the respondent?
Goswami, my lord, Ratul Goswami.
Item 13, na?
14, my lord.
14. R. Goswami, S.I.K. Anyway, where is the complaint?
Complaint, my lord, lordship will find at page 16 onwards, my lord. Appears to be, my lord, civil dispute. There are several agreement between the parties regarding the allotment of the flat, my lord. As the party has failed to repay the amount, my lord.
Where
has been forfeited.
is the, this is the complaint, na?
Yes. Page 17 onwards, my lord. Allotment, then again re-allotment.
Mr. Bora, let us take this matter next week any date. Somehow these names and disputes are coming into my mind. Let me affirm it. Builders ultimately, you know that. Let me verify.
Well,
Just going through the name of that, what is Sarma or something Goswami, what is that?
Goswami problem.
No, not Ratul Goswami, the owner of that company.
Yes, ma'am.
Some?
Kumar Bharali.
Orali.
Pradeep Vallabh Sharma.
Body Vallabh Sarma. Just let me refresh my mind, not today. Please this matter again on. It is give it in the month of January. Hard reopening. Who is this? Is respondent Mr. R. Goswami. He could have anyway. Yes, Mr. Bhatti, what is this?
May I please your lordship? My lord, by this petition I have challenged.
Ah,
I have prayed for the quashing of the FIR.
Hmm.
That your lordship will find at page 9,
page 9.
and it starts from page 11.
Page 9.
Starts from page 11.
Who is for the respondent? State.
State. Food and Civil Supply Department.
BIO.
Yes.
Now, what are your grounds?
My lord, so far the offense alleged to have been committed,
Uh-huh.
the offense which has been alleged
Hmm.
to have been committed, an offense under essential commodity,
Hmm.
and no offense has been made out under section 120B, 420, 406, 426.
Okay.
That is the sort of substance. My lord.
Now, if there is an essential commodities, what is the manner?
Yes, regarding, because I completed, I observed all the conditions of the trade. There's no allegation at all that I have, because only at a higher rate I sold the material. That is the reason.
There is a control order. You cannot
Yes.
sell. You'll have to disclose the
No,
price.
control of the price is not controlled. Price is not controlled by the control order, my lord.
What is that control order? We have passed the judgment. There is a specific control order, where is to be done, what is not to be done. What section 6 says? Essential Commodities Act. Essential Commodities Act says, in violations of any provision or any order under this act.
Yes. under
So
section
therefore,
under
whether
section
which
7
order
of
you
the
have
act.
violated, can we decide here?
Right, your lordship is very right. But so far the FIR is concerned, that has not been registered under.
Yes, Mr. Sahala, what was that matter? BIO, your case? I have allowed your petition. Give a copy of the. In your case, allegation was that you were keeping the materials in a godown which is not permitted.
Hey, officials are.
Now, please tell us, Mr. Bhatti,
Yes.
suppose somebody has committed an offense under section 6. Assuming, forget about for the timing 120, 406, what
Yes,
not.
yes.
Forget about. What is the procedure prescribed? What is to be done?
That can only be prosecuted in the competent court of law.
Prosecuted?
In competent court of law.
No. How is to be proceeded? Tell us that. An FIR is to be filed, a complaint is to be lodged.
No, it is only a complaint.
Why
Because-
are you saying that it is only a
Because-
complaint?
because-
Because of the reason that
Yes,
it is a non-cognizable offense.
Yes.
So a complaint is to be there. No, there is a specific provision like section 199 saying that these applications cannot be filed except without a complaint. There may be provision under Essential Commodities Act saying that a complaint is to be lodged in this manner. Anything?
yes, that is.
What
there.
are those? We want to be enlightened on point of law. Facts will come later on.
Yes, first of all, my lord,
In this particular case, your lordship will see that regarding the penalty, section 7 of the essential commodity page. Now, my lord, your lordship will see that how the complaint can be lodged. That is,
Forget about your case, enlighten us.
I'm coming upon that one. First of all, section 10A, my lord. 10A,
10A of
essential commodity.
give the essential commodity.
It says, my lord, offences to be cognizable and non-bailable,
So
notwithstanding.
if it is a cognizable offense, then what is the procedure?
Offense shall be cognizable and non. Section
Think that I know nothing, just tell us. If it is a cognizable offense, how will it be a complaint?
in that case, the complaint has to be filed, my lord.
If you are not ready, we can grant you some time.
No, I am ready, my lord. Section 11 says, my lord.
You have a method.
One, same matter.
Okay, Mr. Sahola. Let
Yeah.
Mr. Sahola argue first. Okay.
Yes. See, first, here,
What is the fundamental allegation? Please tell us.
fundamental allegation is this, my lord. We are selling Masoor dal
Hmm.
at different rates.
Hmm.
Taking more money, my lord. My lord, this is a wholesaler. They are selling to the retailers.
Hmm.
They are not selling retail. You will also find everything, my lord, that in that we are selling in wholesale.
Hmm.
And
Just see the affair.
yes,
No, just what is to be done when, suppose, forget about 120. See, what, with my limited understanding, what I understand is that offenses are made out, it's a general statement that if anybody contravenes any provision of this act and the orders made thereunder, it will be an offense, cognizable offense. So if that be so, if suppose somebody alleges, makes an allegation, BIO whatsoever, then what should be the procedure?
the procedure, my lord,
Will to FIR.
they can file an FIR or they can file the
A
complaint.
complaint also. That is a
My lord,
difference. So,
both, my lord.
Mm.
But only thing here, my lord, is it is
no,
not.
yeah, we'll come to your case. So that is,
They have not filed it, my
but
lord, under.
that's why I'm asking. Mr. Bhatti has said that no, it must be a complaint. No, you have an option to file a complaint, but this is a moment is a cognizable offense. It can be proceeded.
My lord, here they have not filed it under section 716 of the
Essential complaint. Yes.
because this alleges, my lord,
Hmm.
that if your losses comes to page 18,
Page 18.
second para,
Page
and
18.
18,
Just a minute.
my lord.
In your case. Same affair.
Same. Under the above
Just a minute.
that
Where is the page?
dealer CS Enterprise and New Star Corporation of Pennsylvania, Guwahati is maintaining incorrect books of account and involved in.
Just a minute. Page 18.
18.
Any
Yeah.
type copy?
Yes, that's what.
Okay.
FIR type copy. Under the above section, circumstances, it believed that dealers, CS Enterprise and New Star Corporation, Pennsylvania, Guwahati, is maintaining incorrect books of accounts and involved with speculative malpractice, violating the provisions of Assam Trade Articles, licensing control order, and believed to be reserved for punishment for criminal breach of trust and mischief apart from provisions of EC Act. Therefore, you are requested to register a case for insurance. And this case has been registered
Essential
under
Commodities
120B
Act is
for-
there.
Now, this article's orders has already been, last time I have submitted, my lord, that has
Yes,
been-
Mr. Bhatti, we were not prepared. Sorry to say. I was asking what is the allegation, which order have been violated. You have said that no order is said to be violated. They are specific. Assam Trade Article, LNC Order at 1982.
my lord.
You are not prepared. Sorry. Yes.
My lord, this has been.
There is specific allegation that you have violated Assam Trade Article LNC Order 1982.
That
It's-
order has been declared, my lord,
Ultra virus in that case.
Yes, my lord. That case, I'm giving again copy, my lord, of that.
If that goes,
Yes.
then other part will not come. A similar order,
Yes, my lord, nothing remains. Nothing
30.
remains.
It was not expected from you.
And moreover, my lord, it's a independent, my lord, this is not a public description of articles of order, my lord.
Third, list this method for delivery of orders on, give a date. I'm not keeping well today. That order is there, na? That it was serious. Huh? 17th of December. You are not to sign.
That's all.
Yes, what is this?
Matter maybe fix at 2 PM lordship.
I do not think that we'll see 2 PM.
Lordship, it will be
Subject to
difficult for-
what Mr. Talukdar says. Huh? I do not think we'll see 2 because this is 11:45. Now we have matters left only 1.
Mr. Esikal,
Huh?
next lordship.
What is the issue here?
We have challenged the order of taking cognizance by the judicial magistrate against the accused persons, lordship.
Who is you? Who are you? You are for the informant. CBI or what? No.
Private party.
Private party. Complaint is at page 68.
Yes, lordship.
Huh?
Yes, lordship, 68.
May I please, Your Honor?
Yes. What is this?
My lord, this is with regard to a quashing of a complaint
Hmm.
that has been filed.
Mr. Some seeking adjournment on behalf of Mr.
My
Kyle.
lord, this matter, my lord, will decide on merit, my lord. They can submit their part, my lord. My
No,
part I want to
No, no,
do.
that's true. But
Absolutely simple case, my lord. My,
that's why we see when it's a simple case, you have a merit. Hearing you is not so important than hearing them. Because if we allow your petition, an adverse order will be passed against them. So in that case, it is much more important to hear that. Isn't it?
yes, I put it to your lordship as because it
No,
is.
no, I think so. Yes, when?
Lordship.
2 we have not seen 2. And we'll do not know whether we'll see 2 or not. Huh? How many methods are there left, Mosumi? On one quashing and 1 hearing. One is Mr. Talukdar. I do not think that matter will proceed. Yes, Mr. Talukdar. What is your stand in the affidavit?
My lord, that meant
Uh-huh,
hearing.
uh-huh.
My lord, the department has decided to proceed.
Very well. You have given a copy to all of them, madam.
I'll give them. my lord.
You give a copy. We are taking this matter next week. Okay.
Let his stand be given.
He has filed an affidavit.
Yes.
So serve copies to all the persons.
Yes, lordship may record it that I'll.
We will record it. So therefore, I'm just having an understanding
Yes.
because there is a request to sit at 2. Item 21. Okay, we'll wait for, we'll segregate it. We'll come back to your case. Just
Lordship is
we,
picking up now?
not after something. We'll take after 5 minutes.
My lord, may I propose one thing?
Hmm.
This matter is of 2015, my lord.
There is stay.
I am staying,
We
my
are
lord.
enjoying.
No, that's okay, my lord.
You want to be relieved.
My lord, no, my lord, this may be part heard whenever they want to do.
No,
Let it-
no need to make any part hard. I'm here to clear all this dust,
At 2, my lord.
not at 2.
Then, my lord.
I'm here to clear all this dust for some time. Yes,
Tomorrow, if your lordship.
yes. You come prepared day after tomorrow. No, on Monday. Okay?
On-
Monday you come prepared, whether Kyle is there or not. Okay? We'll help you.
Problem.
On the
Okay,
prayer of,
sir.
the council will respond to Metro State St. John and will be stayed on so and so. so.
Obliged.
Yes, lordship.
What is 30?
Complete 30, I suppose.
Yes. That matter, negotiable instrument. Yes, just you want to show some judgment.
My lord, as I
Hmm.
submitted earlier, in paragraph 9,
Hmm.
they have said that, paragraph 5, my lord, they
Paragraph
have
5.
said that
Hmm.
discharge of
Legal-
legally enforceable
Ah.
towards the complainant, the accused number 2, the
Hmm.
capacity of partner issued 9 checks
Hmm.
and 2 more checks, total 11 checks. But they fail to mention what is the amount of altogether, all legally enforceable debt. What is the
So
amount?
basically failed to mention in the complaint what is the total actual amount
Actual amount,
of legally enforceable
enforceable debt.
debt. So they have failed to mention in the complaint petition complaint what is the actual amount of legally enforceable debt. Though they had made a vague statement that check was issued against legally enforceable debt. Therefore, in absence of such declaration, no case under section 138 is made out, and therefore it is liable to be set aside in cost.
They have also stated
Hmm.
that we purchase stone crushers
Hmm.
from them.
Hmm.
And this is from that amount.
Hmm.
But they have not mentioned what is the total amount. We have
Hmm.
total amount of the machineries.
Total numbers of the machines.
Total, there are 2 machines.
Total number of machines.
Total number of machines and the amount, exact amount for the machines, and whatever we paid, whatever remains.
Okay. So according to you, they have also failed to make a mention what was the agreed total amount of for the sale of the
Two
stone
machineries.
crushers, 2 stone crushers machine, and what amount you have paid and what is exactly the legal due. In absence of such disclosure, it cannot be said that a case under section 138 negotiable instrument is made out. Yes, next.
Next, my lord. Here, my lord, not a single check. There are 11 checks, and the amounts are different, and they have not specifically stated, and all the checks were bounced together.
Okay. And this case, according to you, do not relate to a single check. Rather, the checks involved are 11 numbers of checks. In fact, 11 numbers of checks. Therefore,
Therefore, no specific allegations.
therefore, it is not discernible which check is against what liability.
And in paragraph 8, they have admitted about the sale of
According to
2
para
machines.
8, the Boisha submits that, yes,
They have admitted about the 2 machines which they sold to us. But what is the exact amount?
Okay.
As I stated
Referring to para 8, Mr. Boisha submits that though it is an admitted position, though it is an admitted position that 2 machines are sold, however, if we show exact amount against what is due, what is paid is not there. Yes. Next.
Next, my lord, the legal notice. My lord. For that, my lord, page 51 of the LCR, my lord.
LCF.
This is the initial
Ah,
deposition.
referring to the initial deposition recorded by filed through an affidavit in opposition, Mr. Boisha argues that
In the initial deposition also, the same thing, my lord,
Ah.
nothing has been explained.
submits that in the initial deposition also, it is not disclosed what is the actual amount due and whether any part of the alleged due was paid and what is the remaining amount. Though in the initial deposition also, it is also admitted that there were two machines, and however, there is nothing discernible against which machine what amount was due. Therefore,
Now, let me come to the counter affidavit filed by the respondent.
counter affidavit. Referring to the counter affidavit,
At page
Yes.
17, my lord,
17.
17, my lord. This is the legal notice, my lord.
Just a minute, huh? Because earlier there is no continuation page, no? Okay. Is the affidavit. What is the affidavit, Musmi? Find out the affidavit. Reconstruction. Electric value. Description. Yes, Mr. We should find out the affidavit. No, it is.
Your lordship, once I have a copy, lordship.
It was. Huh?
It was filed on 15/3/18, lordship.
Yes.
My lord, here
Referring
also,
to the deduction notice issued by the complainant. Yes.
here also, they stated about the machine, did not stated the
Did not
amount of the
disclose-
machine.
Did not
Nor-
actually disclose what is the actual legally enforceable dates, except making a statement that checks were issued on discharge of legally enforceable debt. Same thing.
My lord. Basically, in the complaint petition, in the legal.
No
notice and the
disclosure,
initial
what is the
statement,
legal debt, therefore.
Not stated. My lord, now, my lord, section 139.
Section 130, NIF. Placing reliance on section 139 CRP, Negotiable Instrument Act. Mr. Boisha argues that Yes.
Here, my lord.
Hmm.
The provision has been made regarding the presumption. Presumption in favor of holder.
Hmm.
It shall be presumed unless the contrary is proved that the holder of a check
Hmm.
received the check
Hmm.
of the nature referred to in section 138 for the discharge in whole or in part,
Hmm.
any debt or other liability. Now that has been
Yes.
examined by the apex court,
Hmm.
and in this judgment, my lord,
Hmm.
paragraph 30,
1,
30.
30.
The proviso appended to the said section provides the compliance with legal requirements before a complaint petition can be acted upon by a court of law. Section 139 of the Act merely raises a presumption in regard to the second aspect of the matter. Existence of legally recoverable debt is not a matter of presumption under Section 139. So there is no scope of presumption regarding legally enforceable debt. So he has to state, then only he can prove. My lord,
Referring to section, just I will frame it, just you tell us if it is correct, we will record if not.
my lord.
Referring to section 139 of the Negotiable Instrument Act, Mr. Boysa argues that the section 139 Act merely raises a presumption in regard of law. However, it is incumbent upon the complainant to lay the foundation that there is a legally enforceable debt which is not available in the present case, and therefore learned magistrate ought not to have issued the process. In this regard, Mr. Boysa places reliance on the decision of the Honorable Apex Court in the case of Krishna Janardhan Bhatt versus Dattatreya G. Hegre, reported in 2008, 4 SCC 54.
My lord, now,
Hmm.
here, my lord, in the next subsequent paragraph, the apex court held that
Hmm.
what is the how the case will be proved
Hmm.
by the complainant
Hmm.
and how the accused will prove.
Hmm.
My lord, here, the apex court said that the prosecution has liability to prove the case beyond
Beyond
reasonable
reasonable
doubt. But the accused has only to prove the preponderance of probability.
Where is the paragraph?
Yes, yes, ma'am, I will come to that. And it has also stated that if the accused
Hmm.
place on the record about that his defense, like I placed before the trial court below. If it is on the record,
You place before trial court below by what means?
by filing one petition that civil case is going on,
Okay.
and
Okay. Okay.
in the matter is in civil nature, and it's basically a civil dispute. I filed a suit, thereafter they filed this complaint. On that matter, the court said that accused need not to examine himself by placing record only his burden of preponderance of probability done. That is subsequent paragraph. Now let's kindly come to 31. The courts below, as noticed hearing before, proceeded on the basis that section 139 raises a presumption in regard to existence of a debt also. The courts below, in our opinion, committed a serious error in proceeding on the basis that for proving the defense, the accused is required to step into the witness box, and unless he does so, he would not be discharging his burden. Such an approach on the part of the courts, we feel, is not correct. Paragraph 32, my lord. An accused, for discharging the burden of proof placed upon him under a statute need not examine himself. He may discharge his burden on the basis of materials already brought on record. An accused has a constitutional right to maintain silence. Standard of proof on the part of an accused and that of prosecution in a criminal case is different. I'll place a few more paragraphs.
Yes, no problem. We will give
Then
a
I'm
passage.
taking a lots of valuable time.
No, this is our job to hear you.
Paragraph 33.
You should not have any grievance that we have not given you a patient hearing.
My lord,
Because,
I don't
and
have-
we must,
I don't-
yes, we must.
Paragraph 33, Bharat Barrel and Drum Manufacturer versus so-and-so. Here, my lord, G, small g, my lord, towards right-hand side. In this
Placitum G,
paragraph,
the burden upon.
the burden upon the defendant of proving non-existence of the consideration can be either direct or by bringing on record the preponderance of probability by reference to the circumstances upon which he relies. In such an event, the plaintiff is entitled under the law to rely upon all the evidence laid in the case, including that of the plaintiff as well. In case where the defendant fails to discharge the initial onus of proof by showing non-existence of consideration, the plaintiff would invariably be held entitled to the benefit of presumption under section 118A in his favor. The court may not insist upon the defendant to disprove the existence of consideration by leading direct evidence, as the existence of negative evidence is neither possible nor contemplated, and if laid is to be seen with a doubt. Paragraph 34, my lord. Furthermore, whereas prosecution must prove the guilt of an accused beyond all reasonable doubt, the standard of proof as to prove a defense on the part of an accused is preponderance of probability. Inference of preponderance of probabilities can be drawn not only from the materials brought on record by the parties, but also by reference to the circumstances upon which he relies. A statutory presumption has an evidentiary value. The question as to whether the presumption, whether stood rebutted or not, must therefore be determined keeping in view the other evidence on record. For the said purpose, stepping into the witness box by the appellant is not imperative. In a case of this nature, where the chances of false implication cannot be ruled out, the background fact and the conduct of the parties together with their legal requirements are required to be taken into consideration. Now, my lord. Paragraph 44.
Paragraph?
44, double four.
Yes.
The presumption of innocence is human right. Article 6.2 of the European Convention on Human Rights provides everyone charged with a criminal offense shall be presumed innocent until proved guilty according to law. Although India is not bound by the aforementioned convention, and as such, it may not be necessary, like the countries forming European countries, to bring common law into land with the convention. A balancing of the accused rights and the interest of the society is required to be taken into consideration. In India, however, subject to the statutory interdict, the said principle forms the basis of criminal jurisprudence. For the aforementioned purpose, the nature of offense, seriousness as also gravity thereof may be taken into consideration. The court must be on guard to see on merely the application of presumption as contemplated under section 139 of the Negotiable Instrument Act. The same may not lead injustice or mistaken conviction. It is for the aforementioned reason that we have taken into consideration the decision operating the field where the difficulty of proving a negative has been emphasized. It is not suggested that a negative can never be proved. but there are cases where such differences are faced by the accused. That is honest and reasonable mistake of fact. So from this citation, but I want to bring the fact that in such a case, I need not to examine or face the trial because already it is already on the record. It is already on the record that they they have not categorically stated the loan amount, and they have not stated yes what is exact legally enforceable debt. We have to for that we have to calculate the checks. Why? They feel shy. That is not the reason. Reason is that, my lord, in my sale invoice is crystal clear. I have paid the entire amount. That's why they are silent. They are using my security checks. That's why they are silent. What is the exact amount? My lord, in this case, if I face the trial, but from this thing, my lord, all contradiction, my lord, I'll get acquitted. So, why it is necessary? Why I have filed this petition, my lord? For the reason, my lord, as decided by the apex court in Munisami's case, 1977, my lord, doctrine of abuse of process. In a similar situation where civil rights are violated, this criminal case, this criminal liability should not be faster. That is there. For that reason, I have I have come with put that, my lord, case, my lord, Suman Sethi's case, my lord.
Yes,
I am relying paragraph 8, my lord.
paragraph 8. Yes.
It is a well settled principle of law that the notice has to be read as a whole. In the notice, demand has to be made for the said amount, that is the check amount. If no such demand is made, the notice no doubt would fall short of legal requirement. Where in addition to the said amount, there is also a claim by way of interest, cost, etc. Whether the notice is bad would depend on the language of the notice. If the notice, while giving the breakup of the claim, the check amount, interest, damages, etc. are separately specified, other such claims for interest at cost, etc. would be superfluous, and these additional claims would be severable and will not invalidate the notice. If, however, in the notice an omnibus demand is made without specifying what was due under the dishonored check, the notice might well fail to meet the legal requirements and may be regarded as vague.
Yes.
Now, I want to place this Chandranan Ratna Sami's matter, case, my lord. Here, my lord. I'll go to the paragraph, my lord. Before that, head note C may be seen, my lord.
Courts, tribunal, judiciary.
My lord.
Oh.
Court, tribunal, and judicial process, abuse of process of criminal courts, tendency to resort to criminal cases where rather than civil remedies, persons required on part of court, quashment of or stay of prosecution when warranted. Principal summaries, paragraph 33, my lord. Paragraph 33. I read, my lord.
Just a minute. Paragraph, page
Paragraph
100.
Uh.
Paragraph 33.
33, double three, my lord.
Paragraph 761. Yes. Yes.
The doctrine of abuse of process of court and the remedy of refusal to allow the trial to proceed is well established and recognized doctrine both by the English court and courts in India. There
There is no doubt about on this point. We have seen, I have dismissed many petitions on this. This is not necessary.
Yes. So here, my lord, the apex court said that
Yes, abuse of process, no doubt.
when conviction is not possible, then this is abuse of process. My lord.
Any other point? Yes, what else?
My pleasure, Lordship. Lordship, first of all, I would place before Lordship that the complaint that has been filed before the court below has been filed taking into consideration the parameters laid down in 138. Now, Lordship will kindly come that here, first of all, let me explain what is the machine. Lordship, it's a big mobile crusher unit.
These are not.
I am saying because it is required, Lordship. Otherwise,
Yes.
I would not have said it.
Yes, why required?
Yes, why required? Because Lordship will kindly see that it has been asserted by the petitioner out here that the two machine has been sold. In fact, say unit has been sold. And this two machine is component of that particular unit. That means without one machine, the other is incomplete. He wanted a unit crusher, mobile unit crusher machine, meaning thereby he got some supply from NTPC, Lordship.
That we understand. Why we are coming in, this is a mismaking, part missing, not part missing. We'll go by the complaint.
Yes, I am
Let
there.
us see
I
the
am the
complaint.
Lordship.
We do not want any
Yes, yes,
explanation
yes,
what
yes,
kind
yes,
of
yes,
machine
yes,
is.
Lordship.
We
Lordship
want
will
from the
come-
complaint, that's all.
Yes, yes.
Yes,
Lordship
tell
will
us.
kindly come to page number 37, paragraph number 11.
Yes. What
Here
it say?
we have said regarding the machine.
Just a minute. Paragraph.
Paragraph number 11, Lordship. I'll confine myself to the complaint.
You make it confined to your complaint,
Absolutely, Lordship.
and his whole argument is that what is due,
Correct. I will explain that.
and he is
I'll
relying on this. So far relating to his other argument that presumption, not presumption, leading evidence, subject to what Mr. Boyso and what you say, that is at the stage of trial.
Lordship, I
He
have,
may not enter into the witness box. If two cross-examinations are done, you have admitted, or there are materials to suggest that there is nothing in your evidence. Why should he go to the witness box?
Absolutely.
That is what the law is, that there is a presumption of law, that when a check is issued, it is presumed that there is a due, enforceable liability.
Absolutely.
Now, this is only a foundation presumption. that he can rebut. To rebut, he need not go to the witness box. That is what Supreme Court has said.
I am not on that, Lordship.
So therefore, what he is to rebut is that suppose from your evidence for your case, because you will have to prove beyond doubt.
Yes, yes.
Only presumption is there. Presumption will
It
not
is
say
my
that it's
burden. Burden is upon me to prove
Up-
beyond
upon
a
you.
reasonable doubt.
you have an added advantage of a presumption of law. That
That is, that
presumes
139 comes to my savior, that's a different issue.
that's different thing.
Now,
He need not go and produce anything.
absolutely. he
That's
need not
all. So
stand
I
as
do
a
not think,
witness
sir,
also.
this judgment helps anyway in you at this stage.
I leave it to
You have don't leave it to us. You have read a judgment of 3-4 paragraphs. That is dealt in a situation where it was a convicted, this was relating to trial. And what is the principle as regards the presumption? How this burden is to be discharged and what is the onus of the accused? This is what has been dealt. That stage we have not come. Your whole case is that these petition do not disclose anything to take to process to issue process under section 138, and these are the requirements or 130 that is not there. Maintenance there. All these are, I do not think, since you have argued, I have heard it. This is my duty to hear. Now come to that. And
Lordship,
therefore, what machine,
yes.
what not is, we are not on that.
Absolutely, absolutely. Lordship is absolutely correct. Now,
that's
my-
what. So
my
we'll not
only-
go to all this.
My only thing which I need to satisfy. before
Satisfy
Lordship-
that you have disclosed an offense under section 138 on
Absolutely.
reading of it.
Absolutely.
That's all.
Absolutely. Now, Lordship may come to paragraph.
Whether it is against him, how will you discharge, what will be done, that is a matter of trial.
Initial
Yes.
burden is upon me, Lordship.
Yes.
Let me satisfy this honorable court.
Initial burden is you, and you cannot throw any petition saying that there was a. So his
No,
whole
I am not
argument
on
is,
that.
and relying on most apt judgment he has relied on is the last judgment.
I have noted it down.
That is the apt judgment. Others are not relevant at all. Yes. Next.
I won't take Lordship.
Ah.
I won't take.
Yes.
May I?
Yes.
The Lordship may kindly come to paragraph number 11 only for the purpose, Lordship,
Mm.
that what were
Paragraph number 11 of
11 of the complaint. That is
base
page
complaint
37.
starts at
37. It starts that the cause of action arose in favor of the complainant. There,
37. Just a minute.
37, Lordship.
Just a minute.
37 of the petition filed by the petitioner.
Yes.
Your Lordship has kindly got it, Lordship.
Yes.
Now, Lordship will find that there is
Mm.
two component of the machine.
Mm.
Now, why I'm saying two component, Lordship? Because it is a one machine. It's a mobile.
Where do you get that?
Lordship will find booking and purchasing of two numbers of the machine.
Which paragraph?
Paragraph 11, Lordship.
Paragraph 11.
11. Your Lordship has kindly got it, Lordship.
Okay, paragraph.
Paragraph 11 deals with the cause of action.
Okay.
Now, why I'm reading it, Lordship?
Yes, yes.
I'm reading it because
Mm.
Lordship will kindly see
Mm.
that the crushing plant, Lordship kindly see the using of the word crushing plant. Your Lordship has kindly got it, Lordship.
Machines, two numbers of machines.
Mounted primary crushing plant, Metrotech and Terex power screen, made with track mounted primary crushing plant with double deck screen model of Paxson 1000 SR. Now, Lordship, this is a component and one machine is incomplete with the other. So therefore, the cost of the machine will be a composite one. It is 4 crores and odd. Now, Lordship will kindly see there is two component of the payment that has been made. Because Lordship can understand it is machine cost are odd 4 crores, Lordship. 4 crores will not be paid by a person, Lordship. So he took a loan.
Where
Lordship.
do you get all this?
No, not stated here. He took a
Why
loan.
should you go to how he
Yes.
has taken?
Now,
We're not
Lordship, kindly come-
interested with
now,
how you have
Lordship,
taken
now,
loan and
Lordship.
who has purchased.
Yes, yes.
Yes.
Now, Lordship, kindly come to paragraph number 5. These checks, Lordship, will kindly see-
Paragraph
paragraph number 5, page 34,
5.
Lordship.
Okay.
These checks, Lordship,
Mm.
these were not security checks. These checks were down payment checks. And Lordship will kindly see that these checks were issued on 5/11/15. He has issued these checks on one date itself. 5/11/15 it was issued as a down payment of the machine.
Where is that down payment?
No, these are down payment, Lordship.
No, where is that
No, no,
stated?
it's not mentioned.
Tell
It's
us.
not mentioned.
Okay.
It's not mentioned.
So what you said is that in discharge of, see, his whole case, you'll have to satisfy this. Whether it was download, the down payment, security, we are not here to decide anything.
Absolutely.
Okay?
Lordship.
We cannot say this was a downloaded, the down payment check, so it was given in advance. That no, it was a security says he has argued security. We cannot do the.
I am not on that, Lordship.
What is
What
what you will have to
on
show
I am?
is what is his argument. Let us confine to his argument.
I am confining
What-
myself to his argument only.
What his argument is that see, even I do not know what is the legally enforceable
He
due.
knows. He knows. That's what I'm saying. I'm
No,
making out my case.
He says, okay, I will say not he knows, he knows, but he says
He
that
says-
from the any of the paragraph, it is not disclosed what is
it
the
is-
amount
it
of
is, Lordship.
legalable and enforceable due.
It is-
Show us
it is-
that.
it is,
Show us
Lordship.
that.
I'm showing that part only.
Yes,
Lordship.
that part. That is his only argument.
Lordship may kindly see.
Forget about other arguments are not suspectable, rejected. Yes,
Lordship may kindly see. May I just read out, Lordship?
yes.
First of all, Lordship may kindly see that all these checks were drawn on 5/11/2015. If I'm not wrong, Lordship.
Yes,
Now, Lordship, out of which 9 checks amounted to rupees 10 lakhs, 90 lakhs. The Lordship has kindly
Yeah.
got it, Lordship.
Mm.
Check bearing number, very specific.
Mm.
931206 and check bearing number 28174 were for an amount of rupees 11 lakhs
Mm.
and 5 lakhs respectively. So it comes to 1 crore 6 lakhs. He knows about it. That 1 crore 6 lakhs is liability, Lordship.
Mm.
Now, Lordship, come to the second paragraph, 6.
Mm.
The complainant deposited the aforesaid check in its account maintained at Union Bank of India, GS Road, Guwahati branch. On subsequent inquiry came to know on 7/11. 5/11 I was given. I have deposited on 5/11 itself. 7/11 I came to know that it has been returned, dishonored due to insufficient in the account of the accused. Now, Lordship, I take your Lordship to 138.
Mm.
I just read out 138.
Mm.
What are the requirement?
Mm.
May I read it out, Lordship?
Yes.
Where any check drawn by a person on account maintained by him with a banker for payment of any amount of money to another person. Actually, the word classifying words use that any amount of money to another person. Thereby, he is not required to know what is the exact amount of money, any amount of money. Out of that account for discharge, in whole or in part, whether he has given it for a whole or in part, doesn't matter. Of any debt or other liability, it may be debt, it may be any other liability, Lordship, is returned by the bank unpaid, either because the amount of the money standing to the credit of that account is insufficient to honor the check, or that it exceeds the amount arranged to be paid from the account by an agreement made with that bank. I'm on the first one.
Yes.
Such person shall be deemed to have committed an offense and shall, without prejudice to any other provisions of this act, be punished with an imprisonment for a term. These are already there. I'm not coming here. Now, Lordship may kindly see what is the proviso. Provided the check has been presented to the bank within a period of 6 months. Now, Lordship, it is not the case of the complainant, of the petitioner, that it has been placed beyond 6 months.
No, these are not.
These are
This is not his
this-
argument.
These are not at all the ground.
No, therefore, let us not go to that. This is not his case that
I am-
demand was not made within that time.
I am not
Case was
going-
not filed within that time.
I'm not
These
going
are
into-
not cases.
I'm not going into that.
Yes, don't go.
What I just want to satisfy this honorable court, that this complaint
Hmm.
discloses prima facie
That's so that
the
keep your argument.
ingredients of 138.
Yes.
Prima facie it discloses.
Referring to paragraph 5, 2, 4 and 5 of the complaint.
5 and 6, Lordship.
4, 5 and 6 of the complaint. Mr. Bhattacharjee, learned counsel submits that paragraph 4 clearly discloses
Paragraph
the-
5, Lordship.
Please listen to me.
I'm sorry, Lordship.
This is my dictation.
I'm sorry, Lordship.
Paragraph 4 discloses the factum of purchase of mobile stone cursor equipments. Is not it?
Lordship.
This is
Paragraph 4,
yes,
accused number
factum
2
of
is the capacity
purchase of the mobile cursor.
Yes, yes, yes. Yes.
Is it not
Yes,
necessary?
yes, necessary.
Therefore, we started detailing.
Lordship.
Referring to paragraph 5, Mr. Bhattacharya submits that it is clearly stated in the said paragraph that in discharge of legally enforceable debts, the accused number 2 in the capacity of partner of the accused number 1 firm issued the 12th number of checks in favor of the complainant. Full stop. He further contends that the check numbers were also mentioned and the amounts of the 9 checks were also mentioned, and therefore it cannot be said that the complaint has not disclosed the amount of legally enforceable debt. This is your argument.
Lordship, there is 12 check, 9 plus 2.
9 plus 2, 12 checks. Okay.
11 checks, sorry, 11 checks.
He further, referring to paragraph 6, he submits that the said statement clearly discloses that the check were presented in the bank and return memo was issued on 7/11/2015. This intimating the complainant by the bank that the checks has been returned unpaid for insufficiency in the account of the accused, and therefore in the aforesaid factual backdrop, it cannot be said that no case is made out.
Lordship. Now, Lordship, in paragraph number 7, Lordship,
Hmm.
we have referred to the legal notice that has been given.
Hmm.
Now,
Legal notice is not doubted.
Now, what has happened? Now, come to paragraph number 8.
Hmm.
After they have got a legal notice, Lordship,
Hmm.
they develop their case. They say now that the machine is having a manufacturing defect and the machine does not yield the amount which we have at the time of selling the machine. We have said that it will yield that much of the
This is a
result.
factual assertion by him and you.
I'm coming, Lordship. I'm coming. We have mentioned it. It is a factual aspect altogether, Lordship.
Hmm.
Agreed, admitted. And that is the factual aspect with the trial court required to find it out.
Yes.
And then we have written down, Lordship, that the machine has continuously worked for 400 hours. Why not? They have. If the machine was having some manufacturing
These are
defect.
factual aspects, Mr. Bhattacharya.
I'm
Why should we go?
No,
Can you
because-
comment anything on that?
No, because why I'm saying this.
What is his case is that there was a suit filed
I'm
and
coming to that.
therefore it is a abuse of the process of the
I'm
court.
coming
You
to
answer on that.
I'm coming to that,
Ah.
Lordship. I'm coming to the suit filed also.
Hmm.
Now, Lordship will kindly see
Hmm.
that 400 hours the machine has worked.
Hmm.
Therefore, there was no defect in the machine. It's an afterthought. Now they filed a civil suit
Hmm.
at Bongaigaon.
Hmm.
When we came to know that they filed a civil suit in Bongaigaon, Lordship, we have also filed our written statement. Because the suit was first filed in a commercial court, it was transferred to the civil court. Then subsequently, it was again transferred to the commercial court because the amount was more than 3 crores. Now, when we filed a written statement, Lordship, we have argued on the place of jurisdiction because the invoice by which the sale was effected, Lordship, by which they have purchased this
No,
machine.
that we understand. That is not required for this court and that court, your application for rejection or return of the plane has been
I'm coming
dismissed.
to that. I'm coming to that, Lordship. That is why I'm saying the facts has not been clearly stated before this honorable court. I don't know why. Then we filed a transfer petition. When we filed a transfer petition before this honorable court did not transfer. Rather, this honorable court directed that an issue be framed on the ground of jurisdiction. We had again gone to the Bongaigaon court and an issue was framed on jurisdiction. It was heard and the plaint was returned. Till date, the plaint has not been filed. So till date, there is no suit.
No, some Supreme Court.
No. They filed an FAO.
Against that,
FAO.
FAO.
It's pending before this honorable court. But suit has not been filed, Lordship.
Because they, according to them, the order was wrong. Why should they file the suit?
I agreed. Agreed, Lordship.
Oh.
But
So that he have submitted, that we have come against that order. Yes. Don't, you cannot say that he has not disclosed that.
I'm on.
What he said that this was done and we have come before the High Court. Will
They
it
have
mean
come
that
before the High
every
Court.
litigant will have to accept the order? Today, suppose I pass an order against him or against you. You are not bound to go. You can go to the higher authorities. That's all.
Lordship, I'm not on
that is
that.
the legal right.
I'm not on that, Lordship.
Mm.
They have filed an FAO rightly, as
Mm.
to their wisdom.
Mm.
What I'm on, Lordship,
Mm.
that FAO has not stayed the proceeding of the orders passed by the court below.
Mm.
So they should have filed a suit.
Mm.
As on today, there is no suit, Lordship. as on today, there is no suit, technically speaking, there no suit is pending.
Mm.
So as on today, I submit with all humbleness before your lordship that there
Suit
is
is
a
barred by
legal,
limitation.
there is a legally enforceable debt.
That is, you confine to your argument
Yes,
to that.
that is why I'm submitting that there is a legally enforceable debt. And it's a case, lordship, where if the tested to the touchstone of the evidence value, lordship, we'll be able to prove it, lordship. Now I'm coming to 139. I just have one judgment to place before lordship, only
yes.
one judgment.
No. You'll get a chance. Why so your people are so excited?
No.
He let him complete, then you will get a chance to reply.
Did not.
Note it down, what he is arguing and what you want to say.
Yeah, I'm just relying upon only one
Yes.
citation, lordship. It is Supreme Court only.
Mm.
T. Vashant Kumar versus Vijay Kumar
Mm.
on 28 April 2015.
Citation?
It's from the downloaded, lordship. If I can-
Downloaded from
If I can share it. From the
Supreme
Yes,
Court
yes,
website.
yes, yes.
Give a copy. We'll find it out.
yes, lordship. 139. I have just tick. Did you know? মোটা ডেটাই কপি আছিলে জেৰক্স হোৱাটো ভুল হৈ গ'ল
দুটা কপিটো না
ৰ'ব চাওঁ আজি নেকি চাওঁ 139 no good. Submission no good. I have tick marked it, lordship.
That is there. That I
Yes,
have
yes.
already expressed
Yes,
my
yes,
view.
yes.
What is 139? That argument I have said that I have rejected your argument. So far relating to
lordship,
presumption.
Summing up,
Mm.
if I may come down, lordship.
Yes.
That there is a prima facie case against them. And because there is a prima facie case against them, that is why the court has taken cognizance and they ought to have appeared. If your lordship looks into the last line, lordship will kindly see the order impugned that issue bailable warrant of 10,000 against the accused, so and so was fixed for an appearance. They did not. So they came runningly before this honorable court.
That is up to them. Whether we entertain
And I
or
have an instruction, if I say, my brother will not jump upon me.
Yes.
They say that the machine is not working and they have sold the machine 2 years back.
that we are not going to that all.
If the machine is not working.
No, Mr. Bhattacharya,
Lordship,
why
lordship,
should
I
see?
take back my
If
argument.
we talk all these things, this is be a criminal wastage of time, which is not at all necessary.
Absolutely. So this is my argument,
Yes.
Mr. Lordship.
Your whole argument is that if we, in a 482 petition, this court shall quash a complaint only when a bare reading of the material is accepted at its face value.
Absolutely.
No case is disclosed. Your whole case is, please read this paragraph 4, 5, and 6.
Correct.
It discloses there is a liability, discloses there is a enforceable debt, and that's all.
If I may
Rest,
kindly-
whether there is a presumption or not, that is burden, initial burden is upon you, and he can cross-examine, he
Yes,
can
yes, he
discharge
he
his,
can.
if the burden is upon him, he can discharge his burden. Moment he discharges, you will have to prove everything. That's all.
Just summing up one line, if I may kindly.
Yes.
The court, while exercising the power under section 482, cannot enter into the prohibitive, lordship knows about it, prohibitive value of the evidence, so as to carry out a mini trial. All that the court look into the existence of a prima facie case on the face of
That's
the
all.
record.
That is what I have said.
Yes, yes.
Yes,
Which I said
question.
that it's not there.
You want to add something?
My lord, regarding that accepting which is pending. Here, my lord, once I prayed for injunction before your lordship, and your lordship has stated, if we take the order.
Of course,
The-
that's
so that-
exactly, I never remember that I have dealt with matter, but moment he argued, what will be stayed? If that order is stayed, suit will have to be proceeded. That cannot be stayed.
My lord, now, my lord,
That it is a different
That
thing.
cannot be proceeded.
my lord, one citation I missed, my lord.
Yes.
Here, my lord, that 2000 judgment was relied upon.
What boils down is, at the end of the day, whether a case is made out
Or not?
or not, number one. Second is whether in the backdrop of the statement made in the complainant, any further disclosure was required to take cognizance. This is the two issues. According to you, further disclosures were required because they have not stated what is the amount. He says, I have stated. That's all. Hearing concluded, judgment
My
reserved.
lord, this is paragraph 27. Only, my lord, paragraph 27, the earlier judgment which I relied
Hmm.
regarding Suman Sethi's case,
Ah.
that has been relied upon and discussed by this.
Paragraph?
Paragraph 27, 593 page, my lord.
Okay. See, basically, in this case, what is decided sometimes in the demand notice, not only the amount, but also the interest, cost, everything is demanded. So how it is to be segregated, when a complaint is to be dismissed and when not, that has been dealt in these judgments. Hearing
My lord.
concluded, judgment reserved.
My lord,
Very
Ma-
clearly says lordship that 138 prescribes an amount.
Hmm.
We can't go beyond that demand.
Yes, that is what it is.
he, my lord, the
So
liability.
his case is that since it is a prescription amount, there must be a disclosure that this is the liability.
It is.
And that is not there. According to you,
It is
that is already there. We have mentioned, may not be in too many terms, we may not have sum up the entire amount, but we have said that these are the six dishonored for due liability, and these are the amounts against each of the six. That is your case.
And he
My
has
case
issued
is-
this check.
They have to state.
Well, I think I have
Legally
I think I have understood both of
Yes, ma'am.
your
Lord,
case,
Lord.
I suppose. Isn't it? Okay, then let us do it. Judgment reserved.
Deeply
Would have dictated, but not in that position to dictate today.
Deeply obliged.
Keep this also. Yes, next case. Your luck is not good. You are sitting here, not possible. Totally, situation is bad. Yes, we'll give a date.
I only apprehend, but I don't know whether this person is alive or not. Because I've seen the record, he had sustained some accident and the learned court had also recorded that he was
We'll see. Yes, next case. We'll give it this date. I'll just go through the evidence. Almost he has argued this case. We'll just, basic points you have shown. So I'll just go through the evidence. You have already typed it. That I could not manage. Otherwise, I would have dictated this order. Yesterday, I could not manage time to go through this. That's why I'll fix a date immediately. I'll go through that. Yes, Pathak.
My lord, I place this instruction.
Digital affidavit. Then we can file a short.
Therefore, what I'm saying is two issues. First issues, they are saying that suppose I have not seen the affidavit. You have filed the affidavit, Mr. Bush.
Yes, I'll file it, my lord. Lordship only record this, my lord, this letter.
Okay,
Yes,
okay. Oh, I thought that you have already filed because you are supposed to file the affidavit.
In fact, no, my lord, Lordship granted me time because the instruction was incomplete, my lord. Last date, your
And
Lordship
that
is
same is
recorded.
not complete and we'll receive the completion by weekend. Okay. So this is what subject to what you say, Mr. Pathak. Basically, they are saying that we are going for liquidation. This is one aspect. Now, going for liquidation and liquidation is started are two different things. And even if it goes to liquidation, there are many other. Where is Mr. Bhagavati? There are many other cases where there is already orders from this court and orders from the Supreme Court. Now, you will have to address what will happen to those decrease, what will happen? Suppose it goes to liquidation. And if it is not immediately till liquidation is started, what will be the responsibility of them? Okay, and there are some other issues also. So therefore, I think you should file an affidavit giving copy to them so that this is areas we can address, because we cannot simplicity we cannot close that since it has gone to liquidation, so matter ends. No, we will not do that. We'll just go through and try to balance the rights and liabilities of the parties.
Correct.
So, Mr. Pathak, I think this will be the issue after affidavit is filed. Mr. S.K. Talukdar, learned standing counsel for cooperation department on instruction.
Lordship will see the penultimate paragraph.
Submits that that steps are being proceeded to for deregistration of the Escart Bank, a society registered under Assam Cooperative Societies Act 2002, Act 2007. Steps are being initiated to proceed under section 94 and 95
Lordship will indicate
of the Assam Cooperative Society Act 2007 for deregistration of the society in question.
94 relates to cancellation of registration and 95 relates to liquidation.
We are not saying and also accordingly produce a communication dated 2011-2024 issued by the Register of Cooperative Societies Assam, Khanapara, Guwahati 2022, addressed to Mr. S.K. Talukdar, learned standing counsel for the Cooperation Department. The aforesaid communication is kept on record. First, a copy of the said also be furnished to all the learned counsels representing, learned counsel for the petitioners representing the parties. Full stop. In view of the aforesaid stand, in the considered opinion of this court, the competent authority should file an affidavit incorporating such proposal and status of such proceeding, inasmuch as in this batch of writ petitions, grievances as regards non-payment of salary and pensionary benefits are raised. Full stop. Accordingly, matter stands adjourned and released for further hearing on.
I need 4 weeks time.
4 weeks, then what will be the date?
January 1st week, my lord. Because
January
in the
1st.
meantime, there are holidays. So 1 month, my lord, that will cover. That notification of 1 month.
Okay, please propose a date.
On a
Not
hearing,
beyond Bihu, before Bihu.
Yes, yes. On a hearing day, lordship may fix it.
7th of January.
My lord.
Perhaps another issue which may arise, your lordship, is posing the assets which not enough to cover all the previous decrees and the present pensionary benefits. Since it's a government society,
Therefore,
what will be the obligation of the government of Assam to cover
that's
the
why,
balance?
that's why I'm not closing it, because the liquidation process, we might have to make some observation how these people will, what will be their status. That what I want to deliberative on.
Balance, perhaps the government may have to take over because it's a government cooperative.
That's why, say, suppose we may not control or guide the liquidation process, but of course we can declare the right of those persons in these proceedings, not beyond. Once we make a declaration in that effect, that may be a thing which is to be taken note of by the liquidator. So therefore, that's why I have at initiation, I said, I'm not closing this. I want you to respond and highlight all these issues.
Correct.
Okay. That is how Mr. Bhagavati Pathak, just think over it. Okay.
7-1, my lord.
7-1.
Obliged.
Mr. Talukdar also enlighten us in a liquidation proceeding, deregistration and liquidation. Any prescription is there under rules or something,
correct.
how to distribute. See, suppose in a other liquidation proceeding, first right is, say, secured creditor. Then unsecured creditor will come employees and whatnot. So there are prescription in many other statute.
Correct.
What about you in these rules?
Correct.
In government companies, suppose many companies are liquidated in the meantime.
In terms of IBC code, that is done.
Not only IPC, prior to IBC, under Companies Act also.
Companies Act, yes.
So therefore, how is to be proceeded?
Yes.
Why, because there are strata of rights. First search, second search, third search, and rest, anything remains will go to somebody. So I think there are many judgments where says pension and pensionary benefit and other the salaries and all will get the first search, maybe above the secured creditor. So those you will have to highlight. I will not do my homework.
Exactly. This will be the main trust.
Main trust, that is what.
Deeply flexible.
Okay, item number?
21.
It is submitted by Mr. Mohanto in item number 21.
In fact, there is a order passed in earlier.
21, just notice it, that this matter is not part of this batch of writ petition. Accordingly, this matter may be directed to be listed before the appropriate bench. This court, No, how can I take it? I'm taking a criminal bench. This is a writ petition, appropriate bench. Okay. It is seen that this court has also issued similar direction under its order dated 4/10/2024. Accordingly, based to do the needful to segregate this writ petition from the present batch of writ petitions and list this matter before the appropriate bench as per roster.
Item 23 and 24 will remain as part and before.
All part. Not, it is not going anywhere.
That is why
See, problem is this.
Yes.
You'll have to choose one option. Either reconstruct, otherwise this will be all futile orders,
Yes.
passing contempt. Somebody will come and say, I cannot. What will this register will do if he is not having money?
Yes.
He will say, this is not willful the violation. We'll say that this is not willful violation. So at least if it is liquidation, there may be direction to ascertain what is the actual amount against this. Then liquidator may be even some observation getting made. And if you can satisfy, we'll go beyond the brief, no problem on that. If you can satisfy, subject to that.
Correct.
But onus is upon you. We can close this order right now, moment he comes and says that this is as initiated. We'll say nothing survives, liquidator will take his own course. 1 minute will require to dispose of all these matters.
No, Lordship has to balance, must strike a
So
balance.
therefore that I can do
Yes.
only some arguments are advanced,
Yes, correct.
matters are placed.
Well,
Yes.
objection.
Yes, Talukdar,
Revision against conviction, Lordship.
what is the issue?
So he is regarding assault on the on PW1 and PW2.
What is the statement,
Conviction is
evidence of
340
PW1 and PW2?
PW, they have while one was the manager, another was his assistant.
Hmm.
While they went to Bedjan Tea Estate for inspection, and this probably they are the workers, they attacked them.
Okay.
That's the allegation.
What
But
is
they
your
have given
case?
Omnibus statement. 6 accused persons are there. Nobody has been named.
Okay.
And doctor
By
also
the,
found simple injury.
okay. Now
The punishment
conviction,
was 341 for 3 months and 325 for 6 months.
what will you propose then?
Proposal is that because of the fact that and the
So
independent
according
witness
to
they have
you,
not supported.
as if we take the deposition of
Of
the
PW1 and 2.
injured witnesses,
That is PW1 and 2.
PW1 and 2, nobody has implicated this accused except stating that there are 6 persons.
That is omnibus statement.
Omnibus statement.
That who has, because 6 persons, they have found only 2 or 3 injuries.
Hmm.
So who has assaulted,
Hmm.
that they have not established. And the independent witness, that is PW, this 3 and 4,
Hmm.
they are declared hostile. They have not supported.
Yes.
I will injure
I
witnesses are-
injured
this PW1 and
witnesses
2.
is that.
Apart from victim lordship.
That is
another person
no,
is also
this-
there.
That is PW5.
Lordship,
That
PW5 say hostile.
No, PW5 is not
not
hostile.
hostile, no.
Lordship will kindly
PW, what
say,
PW5 says?
PW1 says he was there, Vishnu Tati.
Ah.
But PW2 doesn't say that Vishnu Tati was present.
Okay.
So that remains doubtful whether he was present.
Okay, so who is here? That has not been this. So presence of that witness is doubtful.
Doubtful.
That has
because
not been held.
One has stated he was there,
There
and the other has stated he is not there.
Okay.
PW2 has said he was
Okay,
not
fine.
there.
So his presence is doubtful.
Doubtful.
So, okay, for the time being, for little we keep it aside, then what are the evidences? to take his support.
That is.
That is
really a
PW and PW2. And another eyewitness which has become hostile.
Hostile.
So we'll keep him aside also for the time being.
Also.
What remains is PW1 and PW2. And what is the medical evidence?
Medical evidence is simple injuries there to one.
And what is the
one grievous injury.
conviction?
Conviction is 3 months and 6 months. 3 months under 341 for
Come
restraining.
prepared next
And
week.
325,
Come prepared next week. I took which year?
2013.
13 next week. Next week, no, day after. First week of December. Today, evidences are there. Type or,
I have got the certificate copies. are there.
okay, get a copy or give her a copy. She will get it Xerox. Mosumi, get a Xerox copy of that and keep it in the file. Not feeling well, that's why. List is over otherwise, so that's all.